Thank you, Mr. President. Back again to talk about the bane of my existence tort reform bill. On this one here, I'm looking at specifically line 262, where it says, no owner or occupier shall be liable for negligent security arising from an injury sustained by a person not upon the premises of the owner or occupier. Basically, if you're not on the person's premises, then you cannot bring a suit, which sounds rational and reasonable to some extent. And I'm sure when people come into your office and they say, can you believe that a person could bring suit against us, and they weren't on our premises? But what they won't tell you is where this actually came from. And it's a case called Martin versus Six Flags. It's a horrific case that actually took place. In that situation, a 19-year-old boy was celebrating one of his friends going to college and was severely beaten at the amusement park, and actually now was beaten into a coma and now has permanent brain damage. So what happened there? Investigations showed that the employees of this amusement park were all many of them were gang affiliated. The park was routinely cited as a place of gang activity, both for patrons and employees. The majority of the employees were in gangs. Gang activities were reported on their daily security briefings at least once a week. They were told by the police, you have a gang problem. So on the day in question, 15 to 40 young men, many of them employees of the park, accosted two families. They basically chased the families out of the park, surrounded one family, and when security came of the park and actually dispersed them, when they were actually supposed to make them leave, they did not. One of the guys did a gun signal towards one of the families. So as they made their way back into the park area, they saw the 19-year-old boy with his friends. And testimony would come out that no doubt about it, they were going to accost somebody and hurt somebody at that time. They go up to the 19-year-old, they start basically terrorizing him. He and his friends walk off to the property with those guys right behind them. They hit him with brass knuckles, and at that point in period of time, he was now in a coma and now has permanent brain damage. Part of the amusement park's defense was it didn't happen on our property. But everything that had taken place was because of the fault of the park. Employees were part of the gang, knew that day that these members were accosting families, had been told by the police on many occasions, you have a gang problem. But the defense was, well, they're not quite on our property anymore, so therefore we shouldn't be held liable. And that's what this part of the statute says. Heck, you might as well start having your owner, who does nothing to protect the individuals, sees that somebody's about to get beat up, and they tell the tortfeasor, they tell the party who's going to beat somebody up, hey, can you move 10 feet over there because that's not on our property, and then you can beat the heck out of them. It's not hyperbole, it's real, because that was their defense was. They did nothing to protect those people that day. They did nothing to protect that young man, and their only defense was, well, he's not on our property, even though everything had taken place on their property. And I understand that when somebody comes into your office and tells you, how terrible is it that we can be sued and it's not on our property, they don't tell you the facts of the case that brought genesis to all of this. They leave that part out. Let me tell you, these are your constituents. That young man was a constituent of somebody in here. His whole life, his whole family's life has changed because what did not happen. And to say that he cannot recover because he may have moved 10 feet, 20 feet, 30 feet off the premises is wrong. It is time to stand up for your constituents, and let's move forward. With that, Mr. President, I yield the will.